Lagay mo. Okay na.
Time na rin pa? Oo. Hindi pa po.
Bedroom mo.
Ang siya pang sa labas.
Soldier.
Meron na naman next week. And then 2 weeks thereafter, another one.
Sino yung
When I accepted this, it was from the understanding that temporary issues.
Mas guys.
kuha ka lang.
Diba sa ICC, ang recognize na ng ICC is to the exclusion of patients in Manhattan.
Oh, sorry nga.
Sir, yun pong sa ICC, ang party, at sinasabi ng Secretary Gonzales is that wala ng personality, legal personality in the ABC, but you're contesting that
In the ICC.
Yes, sir. Ano po nag-decide ng Singapore?
The ICC Singapore cases has nothing to do with us. It is correct. We are not involved.
Pero sir, ito po at stake is your...
Oh, this is our petition for mandamus, which is a separate case.
Sir, petition for mandamus ordering you want us to order them to recognize ABC as the original.
That's correct.
Can you elaborate on
to
that
be awarded
point?
the project.
Can you elaborate on that point, sir?
Tingnan lang natin.
Sir, your position. Sandali.
Well, our position has always been that AADC's status as an original component has never been successfully challenged in accordance with law. Consequently, it is entitled to be awarded the project.
Sir, just today there were reports in the papers on investigation of overpricing of the and then possible effects that scheduled delay next year. If with this case also pending at the Supreme Court, is there another possibility that this can be another reason for the delay of the opening of the
I hope not. But again, if the allegations of corruption will have an impact on the integrity of the structure of the building, then I guess that will have to be looked into. But I hope that the allegations of corruption has nothing to do with the integrity of the structure, so that hopefully the opening will not be delayed.
But this continuous argument of AADC that being the original bidder for this proposal, will that have an effect in the scheduled opening for us?
Since you're contesting the...
No, as I understand it, government's scheduled opening is sometime on the first quarter of next year. Given the assumption that the AADC's right to be recognized, we will try to hit the target of opening this month.
Kasi hindi ka na able. So, yun lang. So, ang ikang pagpasok nito,
Rise. The Honor, the Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
Please call the case.
GR number 169914, Asia's Emerging Dragon Corporation versus Department of Transportation and Communication, Secretary Leandro R. Mendoza, Manila International Airport Authority, and GR number 174166, Republic of the Philippines, represented by the Department of Transportation and Communications and Manila International Airport Authority versus the Honorable Court of Appeals, 8th Division, and Salaknib, Baterina. Appearing as counsel for the government are the following: Solicitor General Antonio Eduardo Binachura, Assistant Solicitor General Nestor Balasilio, Solicitor Manilyn Cartula, Solicitor Josephine D. Arias, Associate Solicitor Rebecca E. Khan, Solicitor Jose Yu, with the Solgen Antonio Natura arguing. For counsel for petitioners Asia's Emerging Dragon Corporation, we have Attorney Perfecto R. Yasay Jr., Attorney Eduardo Escueta, and Attorney Elmer Mendoza. Attorney Yasay will argue. As counsel for respondent for Representative sa Lacnip Baterina, we have Attorney Jose A. Bernas, Attorney Salvador Ortega Jr., and Attorney Manuel Fortes. Attorney Bernas will argue.
I would like to notify the parties that Justice Antonio T. Carpio is taking no part, having been a member of a law office which was counsel for one of the parties in the past. So he's not even attending the session today. Have the parties received our advisory on the guidelines on the oral argument today? Do you have any questions before we begin? Yes, Attorney Bernas.
Good afternoon, Your Honors. I filed a manifestation and motion asking that certain other additional issues more pertinent to the case of Representative Baterina be taken up. If the court has no objection, I will take it up in my presentation.
Yes, the court will allow you to discuss those matters during your 15-minute period.
Yes, Your Honor. Thank you, Your Honor.
All right. Are there other questions? There being none, the order of presentation will be first, counsel for the AEDC, second, counsel for Representative Baterina, and finally, the Solgen. Will be given 15 minutes each, exclusive of the interpellations by the justices. Counsel for AEDC is now recognized. Attorney Yasay.
Good afternoon, Your Honors. If Your Honors please, the legal right of petitioner AADC to the award of the NAIA Terminal 3 project is an issue that has not been resolved by any other court and is being raised for the first time in this petition as a consequence of the decision of this Honorable Court in Agan versus Piatco. This right, which is founded upon Section 4A of the BOT law, has been rendered incontrovertible by the Agan decision. Under the BOT law, the proponent whose unsolicited proposal is accepted on a negotiated basis is entitled to the award of the project when no other price proposal is received within the period of 60 working days, or when he matches the submitted lowest price within 30 working days. AADC invested heavily in the development and preparation of the conceptual plans for the NAIA Terminal 3 project. This was submitted as an unsolicited proposal which respondent DOTC accepted for implementation under the unsolicited mode. This acceptance gave recognition to AADC as the original proponent and obligated DOTC to pursue the project and not to entertain any other similar proposals until the period of the Swiss challenge. The Investment Coordinating Committee of the NEDA cleared the proposal, and the petitioner and the respondent DOTC signed a memorandum of understanding committing to fast-track the formal award of the project and its implementation upon fulfillment of all legal requirements. Specifically, Your Honors, Respondent DOTC committed to pursue, implement, and complete the project, and desired for AADC to partially open the terminal by the first quarter of 1998 and to fully open the terminal by the third quarter of that year. For its part, AADC engaged the services of project advisors and consultants to prepare the preliminary designs and tender documents for the major works of the project, incurring more costs and expenses. In furtherance of the MOU, petitioner AADC and respondent DOTC successfully concluded in-depth negotiations covering the scope of the project, arrangements for implementation, and the terms of the draft concession agreement. AADC also pre-qualified to undertake the project using the same criteria for the pre-qualification of challengers. The unsolicited proposal itself was reformatted and validated, becoming an integral part of the draft concession agreement, which was approved by the NEDA ICC for bidding during the submission of the price proposals known as the Swiss Challenge. Petitioner and respondent DOTC, Your Honors, completed the most critical and essential phase of the unsolicited mode. No further negotiation could take place that would materially alter AADC's proposal and undermine the fairness and integrity of the process prescribed in the law and the rules. They reached that final stage, Your Honors, where respondent DOTC would have no option but to immediately award the project either to the original proponent or to the successful prize proponent, depending on the outcome of the Swiss Challenge. On September 20, 1996, the last day for the submission of comparative proposals, the Pair Cargo Consortium submitted the only prize challenge consisting of 3 sealed envelopes containing the pre-qualification documents, the technical proposal, and the financial proposal. The envelope containing the pre-qualification document was opened first on September 24, 1996. And as it turned out, Pair Cargo failed to meet the requirements of a challenger. Under the implementing rules, the technical and financial proposals could not be validly considered for evaluation and should have been returned unopened. However, despite vigorous objections from AADC, the DOTC PBAC unlawfully pre-qualified Pair Cargo. In any event, since the period for the submission of comparative proposals already expired, the fulfillment of the suspensive condition that no other proposal was submitted within 60 working days peremptorily entitled the petitioner to the award of the project. The exclusive, clear legal right of AADC to the award of the NAIA Terminal 3 project, Your Honors, vested when, as pointed out by this Honorable Court in Agan versus Piatco, the Pair Cargo failed to qualify as bidder at the time it submitted its price proposal. By such disqualification, the award of the BOT project to Pair Cargo and the Piatco contracts were declared null and void. As pointed out by this Honorable Court, through the separate concurring opinion of Chief Justice Panganiban, and I quote, Piatco was not qualified to participate in the bidding process for the Terminal 3 project, but was nevertheless permitted to do so. It even won the bidding and was helped along by what appears to be a series of collusive and corrosive acts, close quote. By this pronouncement, Your Honors, it is clear that from the start of the Swiss Challenge, respondent DOTC never intended to award the project to petitioner, but already decided giving it to Pair Cargo because of graft and corruption. The vesting of AADC's legal right gave rise to the corresponding statutory duty on the part of the respondents to immediately award the NAIA Terminal 3 project to petitioner. This duty forbids the respondents from taking over and operating the project or awarding it to third parties because the vested legal right of AADC is to the exclusion of anyone else. The invalidation of the award to Pair Cargo and the nullification of the Piatco contracts by this Honorable Court in the Agan case removed the only hindrance to the performance of respondents' statutory duty and commitment under the MOU to award the BOT project to the petitioner. Mandamus is therefore proper remedy in this case because, as already pointed out, petitioner, as the unchallenged original proponent, has the exclusive, clear, and vested right to the award of the NAIA Terminal project. This right has not been waived, abandoned, and has not prescribed. On the other hand, respondents have unlawfully refused to perform their statutory duty that is reinforced by the contractual obligation or commitment to award the project to the petitioner. This, Your Honors, amounts to a nonfeasance of a legal duty, and the latter has no other plain, speedy, and adequate remedy in the ordinary course of law. In furtherance of this refusal, respondents have acted hastily in the expropriation case pending in Branch 117 of the RTC of Pasay City to comply with this Honorable Court's decision in the Gongoyon case that government may take over the terminal facility upon payment of just compensation to Piatco. Your Honors, one of the conditions for the acceptance of an unsolicited proposal is that the project must be privately funded and should not involve direct government guarantee or subsidy or equity. This alone makes the expropriation of NAIA Terminal 3, which involves the disbursement of improperly appropriated public funds, irregular. However, the grant of this petition will uphold the BOT law because petitioner will assume the obligation of completing the project at no cost to government and pay Piatco as builder of Terminal 3 under the principle of unjust enrichment consistent with his Honorable Court's holding in the Agan case. Your Honors, the Agan decision has not removed NAIA Terminal 3 from the coverage of the BOT law. In fact, the nullification of the Piatco contracts was done to comply with the BOT law. On the contrary, the Agan decision enabled the recognition of petitioners' vested legal right and the performance of respondents' imperative statutory duty and contractual commitment so that the NAIA Terminal 3 can be carried out and completed pursuant to the BOT law. It also created an obligation based on equity to compensate Piatco as the builder of the unfinished structure. Your Honors, the Piatco contracts were declared null and void because, as succinctly pointed out by this Honorable Court, irregularities galore and insidious contraventions of law and public policy have riddled the process by which they came into being. Seen in this light, to accept the argument that the nullification of these contracts terminated the BOT project would be to reward Piatco and unjustly punish AADC, whose preferred status as original proponent is protected under the law. This leads to the final point, Your Honor, that AADC's right is also grounded on equity. It submitted its unsolicited proposal to help solve the infrastructure problems of the country. It faithfully complied with all the requirements of law in the preparation and implementation of its innovative proposal at tremendous costs. It negotiated with government in good faith, and the only reason it did not get the award was because it fell victim to blatant anomalies and irregularities. The recognition and enforcement of its right would not be injurious to anyone, and the objections to the validity of its claim are simply based on procedural technicalities. Your Honors, under these circumstances, to deprive petitioner of its vested right would amount to a grave injustice and would not serve the best interest of the public. Thank you very much, Your Honors.
Thank you, Attorney Asay. Now, for questions from the court, Justice Corona.
Counsel, can you enlighten this court on the business and legal implications of giving NAIA 3 back, or giving NAIA 3 to AEDC as an original proponent under the BOT law?
The business implications, Your Honor?
Business and legal implications.
Well, the business implication, Your Honor, is that, well, to begin with, the business implication will be that the project will be completed. The Terminal 3 will be operational as soon as possible. And the commitments of the respondent and of government to the original proponent will be properly recognized in accordance with the BOT law. The legal implication, Your Honor, to award is really to uphold the provisions of the BOT law. As I pointed out earlier, the real purpose why petitioner AADC was not given the award is precisely because government at the time of the Swiss challenge never really intended to give it to AADC, but was compelled, or because of anomalies and irregularities, to give it to Pair Cargo. Now, this very clearly, as pointed out by this honorable court, was in violation of the BOT law. The legal implications, therefore, of granting this award to AADC will be to uphold the BOT law, and would even uphold the provisions of the other laws with respect to the expropriation of this property, which from our position, Your Honor, will not be appropriate.
Okay. Are you aware of any legal precedent supporting your argument?
Well, Your Honor, insofar as the grant of mandamus and prohibition is concerned, I would like to allude to the case of the Manila Hotel Corporation, Your Honor, where very clearly this court granted the mandamus precisely because there was a duty on the part of government to award the contract to Manila Hotel, brought about by the provisions of the Constitution to preserve the patrimony of the nation. So this in fact is applicable to the case of AADC, Your Honor.
Did the nullification of the award to Piatco terminate the nature of NAIA 3 as a BOT project?
It did not, Your Honor. In fact, a reading of the Agan case, Your Honor, which nullified the Piatco contracts, precisely undertook the nullification to uphold the BOT law. The decision of this honorable court was limited only to the nullification of the contracts, but the project itself, Your Honor, stood intact.
On December 19, 2005, this court promulgated Republic versus Lingoyan. Can you enlighten this court on what might be the possible effects of granting AEDC's petition on that decision?
Your Honor, it is my understanding in the case of Gingoyan that the issue of the propriety or legality of the expropriation was never brought up before this honorable court. What this honorable court decided in that case was, because government undertook to expropriate, it cannot take over the property unless it would pay Piatco fully just compensation. The grant of this petition by this honorable court to AADC, Your Honor, will precisely stop the expropriation from proceeding and will lead to the correct solution on how to address the rights, obligations, and responsibilities of government, PIATCO, and AADC altogether, as seen in the context of the BOT law, Your Honors.
Now, in Gingoyan, we declared, and I quote, "There should be no question as to the propriety of eminent domain proceedings in this case," unquote. Are you therefore asking us to again decide the propriety of the expropriation proceedings? Are we going back again
As I
to that
understand,
expropriation issue?
As I understand, Your Honor, that is an issue that will be appropriately discussed by Attorney Barnas, because his client was the one really actively involved in the Gingoyan case. AADC was never involved in the Gingoyan case, Your Honor. So I would like to defer to Attorney Barnas insofar as that position is concerned. I have been advised about the position he has taken on this, and I would like for the court to be enlightened in this respect by reason of his...
But what do you personally think?
I personally think, Your Honor, I think that this honorable court will have to abandon and order the stopping of that expropriation because it is unlawful from the viewpoint of this representation, Your Honor. To begin with, we feel very strongly, and the facts as admitted no less by the Solicitor General in his expropriation complaint, that the land on which Terminal 3 stands is owned by government. In its complaint, it admits that it is owned by AADC. Republic Act 8974, Your Honor, which is the implementing law, as I know, with respect to expropriation, provides that the expropriation of property that will be used either as a site or location for infrastructure project, as in this case of NAIA Terminal 3, refers to land or real estate. So in this particular instance, the land on which Terminal 3 stands is already owned by government, and for government to expropriate this property would be, Your Honor, unlawful. But more importantly, this honorable court in Agan versus PIATCO said that under the circumstances it found with respect to the award of the contract and the nullification of the contract, said in no unmistakable terms that PIATCO should never be allowed to profit or reward from Terminal 3. In fact, to reward or allow PIATCO to profit would be unconscionable, as pointed out by this honorable court. To pay just compensation under the exercise of eminent domain to PIATCO would be, in effect, awarding PIATCO for Terminal 3. Because to begin with, PIATCO is not the owner of the land on which the Terminal 3 stands. And the standard at which just compensation is to be measured will be based at least on market value that will also involve a consideration of returns of profit. In fact, PIATCO, in its claim in the ICC Arbitral Court in Singapore, had asked for $565 million in the form of just compensation. I do not believe, Your Honor, that government is prepared or would be willing to pay this amount. But on the other hand, if we were to follow the decision of this honorable court, the holding of this honorable court in Agan versus PIATCO, that PIATCO should be paid compensation which is just based upon the principle of unjust enrichment, then we apply the standard of quantum meruit. And this, Your Honor, we feel is the more correct approach.
Now, why do you take the position that the DOTC has no authority to take over the NAIA 3 project to the exclusion of AEDC or to award the project to third parties?
Because that is what...
legal basis.
Thank you, Your Honors. Your Honors, that is what the BOT law says. The BOT project, known as the NAIA Terminal 3 project, was accepted and approved on the basis of the unsolicited proposal of AADC. And one of the conditions for the approval of an unsolicited proposal as a project is that government cannot subsidize, cannot guarantee directly, cannot infuse equity directly. The expropriation of Terminal 3 by the takeover of government in this particular instance will require government to pay. which is precisely what the BOT law prohibits, Your Honor. That's why we say, this representation claims that the obligation of government is to award the project only to AADC, and it cannot even take over the project because it will be violating the BOT law, Your Honor.
Okay. Considering that the government has already paid the proffered value of 3 billion pesos under the Republic Act 8974, does it still have the power to award the project back to AEDC?
Yes, Your Honor, for the simple reason that the expropriation proceedings has not yet been completed. In fact, should the Honorable Court make a full determination of the issues that have been raised here and make a determination that expropriation is not appropriate or the legal mode, then this amount of 3 billion can be held in trusts by Piatco for purposes of crediting it to whatever amount may be determined that will be payable to Piatco in the form of reasonable value of the terminal facility based on quantum meruit, Your Honor.
Okay. Everything I have read so far from your pleadings, as well as those on your side, talks of rights, that AEDC has the right to get back the project, etc., etc. Now let's talk of obligations. If the project is awarded to AEDC, what will be AEDC's obligations to the government under the BOT law?
Under the terms of the contract bidded out, Your Honor, which emanated from the original proposal of AADC, government or AADC is obligated to finish the terminal facility. As it is now, according to reports coming no less from government, it will take about anywhere between 80 million to 100 million US dollars to complete the project. AADC is ready and determined to perform its obligation in this regard, which has not been rendered impossible by the nullification of the Piatco contracts. AADC, Your Honor, is also to prepare to carry out the obligation based on equity to pay Piatco compensation based on quantum meruit as builder of the facility. AADC is willing and determined to do this as well. As I understand, there are obligations payable to the general contractor, Your Honor, which AADC at this point is also willing and prepared to pay. And then AADC on that basis can operate the terminal facility on the basis of the terms of the concession agreement that was the contract bidded out, and then transfer the property at the end of the 25 or 27-year period back to government, Your Honor.
Anyway, just one last question, Counsel. Finance people talk of a term, quote-unquote, it's called going concern value. While that term may not be completely applicable in the sense that this is not yet a going concern, the fact remains that the building is already there and so much work and trouble and time and effort has gone into it. Are you going to give a value to that, to what might amount to be an equivalent of the going concern value, in the sense that the building is already there and most of it has already been done? Are you willing to pay an equivalent value to the government for that?